This is 202 Parkside. Here, the administration officer, as you can tell, this is a update. We're going to have everything processed, sent at the fashionably ordered. We're going to start from Wyoming Supreme Court. And this is Wyoming Supreme Court, April 15, 2019. Gibson versus State, Civil Rights, Constitutional Law, Criminal Law. Myers. Wyoming, Gibson State. Supreme Court affirmed defendant's conviction of one count of possession with intent to deliver marijuana. Now we go Kansas Supreme Court. Kansas Supreme Court. The new verdict bypassing Constitution text legislation is coming in effect. Kansas Supreme Court, Estates of Grabber versus Dillon Companies, docket 11342112, 113412, April 2019. Judge Dan Biles, Area of Law, Government Administrative Law, Labor, Employment, Personal Injury. An appeal concerning the statutory definition and idiopathic causes. Idiopathic causes contain the statute excluding benefits of certain accidents or injuries. The Supreme Court held Workers' Compensation Appeals Board improperly denying benefits to Terrell Garber. He was injured and he fell down the workplace stairway, holding that there was no substantial competent evidence to support the board's finding of the accident or the injury arose indirectly from the inappropriate cause under the statutory exclusion. There was evidence presented in the case showing why Grabber fell down the workplace stairway. The board constructed the term idiopathic cause in Kansas Stat Ann 44-508 F3A broadly in the cover of all unknown causes denied compensation. The court appeals the reverse. After defining the term of narrowly, Supreme Court affirmed remand in case the board of reconsideration consent with his opinion, holding the term of idiopathic cause contents means medical conditions, medical events, unknown origin of particular to the injured individual. Let's go into court notifications, court rules, court rules at listerv.courts.w.gov. Washington court rules published notification. Let's go Georgia Supreme Court, April 2nd, 2019. Georgia versus Spartan, Constitutional Law and Criminal Law. Jackson versus Georgia, Constitutional Law and Criminal Law. Supreme Court of Georgia, Georgia versus Spartan. Docket S18A1158, March 11, 2019. Judge David E. Nemes. Areas of law is constitutional law, criminal law. Appellee Dijon Spartan was convicted of malicious murder, a firearms offense, in connection with shooting death of Edward Cobb. The trial court granted Spartan a new trial, however, on the grounds that the trial counsel provided effective assistance in failing to seek exclusion of testimony and comments about post-arrest silence, and state appealed that ruling. That Georgia's Supreme Court concluded that there was not reasonable probability, but the limited deficiency of performance by Spartan's trial counsel and their jury trial have reached different result. The court therefore reversed under granting Spartan a new trial. Jackson versus Georgia, docket S18A1598, March 4th, 2019. Judge Bethel. Areas of law, constitutional law, and criminal law. Atlas Jackson was convicted by jury of malicious murder and other crimes in connection with 2018 death of Stephen Lewis. Jackson appealed the denial of the motion of the new trial, arguing evidence was insufficient to support his conviction for burglary, that the trial court committed planned error, and that change in jury regarding constitutional evidence of the good character